All right, welcome back for week 3 of environmental law. This week we'll look at the Clean Air Act. I am once again here behind the blue-white microphone. Why do I call it that? I call it that because the microphone looks like this. It's blue brand, but it's a big white ball, and it clicks up to my laptop just like that. And hopefully, as you may remember, Chapter 2, I had to re-record all of them. Hopefully I'll get them right first time this way. But it's white color, but it's called blue, which reminds me of this little exercise here. And the thing here, you can hit pause if you want. I won't leave it up forever, but see if you can say the colors of the words, not what the letters spell, but the color that the letters are as you read through. It's not an easy thing to do. Put this up in tribute to when I first started teaching environmental law, and I didn't have any stories or any fun things to tell, and I was still learning a lot myself. I used to do a magic trick for the environmental law class. Just about every day I would come in and do a magic trick so we'd have something fun to talk about. Often when I see my old students, they'll still ask me whether I still do magic tricks. Don't really, but this is kind of close to one for you. All right, and today we will be talking about the Clean Air Act. We'll talk about that. In the first 2 lectures this week will be about the Clean Air Act. Really, today's will be a little bit more about history than the first one. Then the second one will be a little bit more about the Act, although we'll get into that some today. The third one will be more about OSHA. OSHA, the Occupational Safety Act that employers have to look out for. Because if you think about it, environmental exposure often to air pollutants is very important in that matter. Now, in the PDF files for this week, you'll see an entire copy of the Clean Air Act. It's about 300 pages, so I used to, back before we had computerized stuff, students had to buy a statutory supplement for this course, and it was a pretty expensive book you had to buy that had the Clean Air Act, Clean Water Act, a lot of regulations and stuff in there. I don't have you do that anymore. I try to put what you're going to need in with PDF files. Now, I don't expect you, and I would not if I were you, print out all 300 pages of the Clean Air Act, but pull it up, maybe save it to your computer so you can look at the relevant statutes as we go through. What you might want to print out, have handy, as I gave a very brief summary, it's in a Word file that just sort of is a quick directory. Will help you kind of know what the Clean Air Act is as we go through, and maybe you can use it. That'll direct you to a point. Then you'll see, what section relates to a certain thing, and you may want to flip to that page in the Act itself. And you see here, this slide talks about the 3 different titles. First of all, stationary sources of air pollution. Talking about factories there, that pump the smokestacks out in the air. Then you have cars, trucks, and aircraft in Section 2, Title 2. And the third title relates to various I would call it civil procedure kind of stuff, administrative and judicial review, what you have to do to get to court and what your rights are there. Why is so much attention given to stationary sources? Well, if you look at this graph, you see more than half of the air pollution slightly more only, is deemed to come from industry. You then get a little bit more than a quarter of it comes from transportation, cars, trucks, planes, stuff like that. And then you've got some other areas there with smaller groups. But obviously industry and cars make up more than 75% of air pollution. The cumulative impact of pollution in the air was not realized for a long time. Back in the 1960s and 70s, there was it was almost a joke about how there was smog in Los Angeles, or Pittsburgh was known to be that way. There's that old poem about I shot an arrow in the air, fell to earth I know not where. I remember was on television somewhere. I shot an arrow in the air and it stuck. It was about Los Angeles. But there would be some specific episodes, some times when it would become so bad in an area or whatever, and that you couldn't ignore it. And they would see people start coughing, and they would realize that there was some correlation between the pollution and health. And this Denora smog incident is something that I had read, just made reference to here and there, and didn't know much about it for a long time. Then a couple years ago, I was reading the book you see up there, Stan Musial biography. Stan Musial, great St. Louis Cardinals baseball player, and he grew up in Pennsylvania. And there's 2 pages suddenly that are talking about when this smog descended upon the town he was from, the area he's from. Forget if he was directly from Denora or just near there. I think he had an uncle who died, or at least got very sick from it. About 20 people did die. It was an enormous tragedy. If you look at the picture in the upper left-hand corner there, that's daytime, and this came and it lasted for several days. This they call it a fog, but really it was pollution, not just moisture. And finally it left, dissipated when rains kind of broke it up. The factory didn't shut down until just before the rains came. I mean, they kept pumping the stuff up. You see the pictures around there and all. But this was at a time when this kind of attention, this kind of disaster caught people's attention, but we weren't thinking in terms of small amounts and cumulative amounts and the things we worry about with pollution today. But this was very important. By the way, there's a History Channel special on this that I saw. You might, if those of you who watch the History Channel. History Channel now, of course, is mainly about pawn shops, but it used to have actual history, and there was a special about this I watched within the last year or two. London had very bad pollution. Everybody used to have a chimney over there where they would burn coal, and the coal would come pumping out. And there's a little picture there of Dick Van Dyke from the Mary Poppins movie. By the way, I recently saw Mary Poppins on Broadway, and done very well too. But the chimney sweeps were up. That was a job a lot of people had to do. I don't think they have them anymore. You can get your chimney swept out, and if you have a chimney, you need to have it swept out for safety reasons. But it's not like it was. People aren't burning coal, and chimney sweeps, by the way, develop black lung disease. It's one of the things we were talking about earlier. You're a chimney sweep all your life, and when you're 55, you begin to develop this disease, and you don't realize that you really were exposed to pollutants that caused it back in the 20s. And they began tracing health effects in the chart there, health effects compared to pollution, and seeing that there was a definite correlation, at least. And today I think we'd say there's a definite causation. Here you can just see some issues of how air pollution evolved. We start seeing the smog in Los Angeles in the 1940s, air pollution, and they begin to try to to establish districts. And you see you have a big problem just outside of Pittsburgh in Pennsylvania in 1948. Began to have meetings to discuss it in 1949. States begin to take action. Oregon in 1951. London has a horrible situation with the pollution in 1952. Ozone levels go up really high. By the way, you may have heard about ozone, hole in the ozone layer, or thinning of the ozone layer. There is a layer of ozone in our atmosphere that is beneficial to the planet. The so-called hole in the atmosphere isn't as bad as it was thought to be 10 or 15 years ago, apparently. But the funny thing about ozone is it is thinner and it is being depleted in the higher levels. and that's bad. It's increasing down around where we breathe, and that's bad too. If there were a way we could, get the ozone that's down that we breathe and shoot it up high into the ozone layer of the atmosphere, that would be good. But you'll often hear about ozone reported as a pollutant. That's talking about ozone that is here at the level where we breathe. Ozone being depleted at higher levels is a problem. And President Eisenhower in 1955 began to ask Congress to study these matters. When we began to study the effects of air pollution, we saw that there were a lot of premature deaths every year due to air pollution. Children had lessened lung function. They grew up around air pollution. When people were exposed to particulate matter, that's the residue in the air from combustion engines and stuff, greater chances of bronchitis, asthma, cancer. And in autopsies and such, we saw that people who lived around these areas, had damage to their lungs and their bronchial glands, and they had problems. And so it became clear that air pollution was leading to serious health consequences. The Clean Air Act, as we know it today, really probably, if you were going to point to, you'd say it's the amendments that took place in 1970 and maybe 77, but they trace all the way back at least to 1955, an Air Pollution Control Act that was, not much more than sort of giving advice and here's things that maybe people should do, and so it's a phase-in thing, a gradual thing. Get people used to the idea that we need to be watching out for the environment. Clean Air Act was put in place in 1963. Still did not do much at all in terms of actually having any teeth. Same in 67. 1970, you start to see the Clean Air Act actually mean something, and it develops to what we have today. Now, if you think about trying to attack air pollution, you realize that there are several complexities that you need to deal with. One is the technical complexity. How do you create the things, do the things we need for our society without creating the pollution? Is there some way to make stuff, to create energy, to have electricity, and all the good things that electricity brings to us without polluting? If not, what's the trade-off? Can we do without electricity? Or is there some way to do with less electricity? You have to look at all of the various products. It's not one electrical plant we're looking at. We're looking at a million different sources of pollution. So how do you cover all the different sources? And what is what's the administration? How do we do this? What kind of level of review do we give people? Do we have hearings? Do we, there's a lot of stuff here trying to figure out. And so I guess that's sort of why the Clean Air Act evolved over all these years. There are also different ways to enforce the rules. There's the so-called command and control kind of enforcement, where we say, here is how you will do things, here is the process you have to use, the technology you have to use, and it will be done this way. While that has certain advantages, it has some disadvantages too, in that it tends to stifle innovation and creativity. So sometimes you try to have market or incentive-based regulation, which encourages people to develop new ideas and reward them. The whole patent process, if you think about it, kind of works that way. If you get a better idea, we let you be compensated for it. So how do you enforce something? There's another issue similar to this we need to talk about. As I said, the Clean Air Act grew out of these earlier acts. The 1955 Act expressly said that prevention and control of air pollution at its source is the primary responsibility of state and local governments, which does raise an interesting question we should think about as we go through the rest of the chapter. Should these be national issues, or are they local and regional issues, because air pollution certainly varies. We live in an area where there's very little air pollution in Mississippi. Some of you may be working this summer in some cities that have much more dangerous levels of air pollution. Does it make sense to regulate that at a national level, or as originally was done here at a state and local level?
Actually makes for a pretty interesting topic for a post. So why don't we have Caitlin Bagley? Is there pronounce the D or not? Anyway, Caitlin, why don't you start us off on that? Have a discussion about whether environmental regulations should be based regionally, state-based, nationally. How should we set those standards? And how about Justin Bouchard? Why don't you follow up with that and respond to Caitlin? Bring up maybe some different points, see if there's any weakness, and the rest of everybody follow in, and we'll maybe get an interesting debate going about this, because there are differences. Should it be different with air pollution, water pollution, all those kind of things? Think about it a little bit, and let's have a posting on it.
In 1963, the Clean Air Act created, well, it gave the Department of Health, Education, and Welfare the authority to create air quality criteria. Now, these were not mandatory, but they established the idea of we will have a certain level of cleanliness in the air. You didn't have to meet them like you do today. Today there are consequences if your local municipality is not sufficiently clean in terms of its air. But, I mean, you can see this is a progressional thing. Kind of like, I mean, an analogy is the seatbelt law in Mississippi. When it first came in, I don't know, 15 years or so ago, there was no penalty for it. It was just, we're having a law that you have to wear a seatbelt, but don't worry, you can't get a ticket. And then you can't be stopped for it. It's only if we sort of accidentally discover it. And now, at least in some other states, I don't know if they do this in Mississippi yet, they actually have checkpoints where they pull over and look just for seatbelts. And I know that because today, the day I'm recording this, there was a photograph that a police officer posted on his Facebook. In the back seat, there was a child sitting not in a car seat, apparently not in a seatbelt at all. However, a gas can was strapped into the child's seat. So it appeared as if the parent had strapped in the gas can and let the kid run free. The parent, according to the police officer, said the kid had done it. So I don't know, just sort of an interesting observation.
And here is that mom. Here's the picture of the kid with the gas tank in the car seat, which I don't know if the gas tank is in there properly. So I mean, I think that the seat lap should go around in front of it, right? So even it's not done correctly. But I'd hate to be the mom. You know what I'd hate to be? I'd hate to be the dad. I'd hate to be me if my wife caught me in something like this.
The 1963 Act also, for the first time, started talking about cars and authorized the creation or prescription of practical emission standards for motor vehicles. Also gave the HEW authority to intervene in certain pollution issues with the state. Still very limited role for the federal government under that statute. 1965, you begin to see the real first time the federal government gets involved in closely regulating cars, creating standards for different pollutants here. And for 1968 model cars, patent after, California had some earlier regulations, so the feds started copying some of that. Of course, most of the cars didn't meet the standards. Early in the process. My first car was a 1969 VW Bug, which I guess would have had to meet these. Now, perhaps the most important thing in terms of these early regulations relating to relating to vehicles was a regulation of lead in gasoline. Lead used to be inserted into gasoline. It helped cars have less knocking and pinging. It made them run more smoothly. It was an additive. So when we hear unleaded today, coffee is decaffeinated. The caffeine is naturally in the coffee, and you have to take it out. Lead is not naturally in gasoline. You either have it leaded, which used to be the standard, it all just was, or unleaded, which means we haven't put lead into it. So today we talk about unleaded. It's from a time when we used to always put lead in. Lead is something that's very hazardous. Of course, we now know it used to be in paint, and kids would chew on the walls, or what, little kids or whatever, and they didn't just paint that way, and it affected their development. They would breathe it because it was in the air because of gasoline motors and stuff. So it's a very dangerous thing, we now know. And it's one of the things that probably, as much as anything else, has had an enormous environmental, an improvement in our environment from banning lead. Of course, there was the important thing that lead could do, and that was, here you see Jimmy Olsen was able to put kryptonite inside a gas tank that had lead in it, and the lead would protect Superman. Unfortunately, with unleaded gasoline, it can't protect Superman anymore. And if you don't know Superman, lead is like one thing you can't see through, and kryptonite can't impact him through. We're going to look at a case later on in this lecture about lead, but we'll wait till we get up to the current Clean Air Act before we talk about it. 1967, you get the Air Quality Act of 1967. Congress's first attempt to really create a comprehensive regulatory program for air that had a number of factors to it, including creating air quality standards, ways to meet that, various control techniques, looking at various atmospheric areas, breaking something down so that it's not strictly in terms of state lines, but really geographic regions we're looking for. Some of the things that this law did, create the regions like we're just talking about, also required publication of criteria reports so that you would test and figure out how good or bad your air was. Have scientific reports about the effect of pollution on the health and well-being of people and such. Provide information to help science develop. States were required to set their own quality standards based upon the information set forth pursuant to this law. Well, that leads us then to the Clean Air Act amendments of 1970, and this is really the introduction of the Clean Air Act as we know it. Now, it's been amended since 1970 as well, but the amendments since then have been fairly minor. The Clean Air Act of 1970 created, for one thing, the Environmental Protection Agency, which, of course, is such an important agency today for environmental matters. It also established, however, the fundamental structure of the Clean Air Act, which we're going to talk about here in a minute, but it's the development of two different standards of quality of air. Okay, now, when we talk about ambient air quality, if you can imagine, we're not talking about what's coming out of the top of a smokestack. We're talking about, suppose you can take a cubic meter of air. You could take a bushel basket and fill it with air, and as a cubic meter, whatever, a quantity of air, and then test that air and find out how much of any given pollutant is in that air. That's what an ambient air quality standard is. It says the air has to be at a certain level of cleanliness, and we're going to have two standards, in fact. We're going to have the primary standards. The primary standards are designed to protect human health, and By human health, we look at the most vulnerable group, whatever that may be. It might be the elderly, it might be children, whatever. Human health, we're going to look at it's got to be clean enough to protect them, and we're going to have hard and fast time limits. Originally 2 years, and it varies a little bit in certain cases, and there's a possibility to get a variance, but in essence, there's going to be a very strict time standard, and it has to be met, and if you don't meet it, whoever's creating that pollution will have to stop. Okay, that's the idea. Then there are also secondary ambient air quality standards. The secondary ambient air quality standards are designed to protect public welfare, and basically that means plants, animals, buildings, anything but human health. So if you find something that, and the idea is those also will come in, they can be phased in a little bit over a little bit longer period of time. They are not have to be 2 years or shut down. They are a little bit more of the idea of a reasonable time. How long will it take you to do it? Well, science has to figure out how to do it. When it comes to human health, boom, you got to get it done in time or we're shutting you down. When it comes to animals, plants, buildings, you have to do it within a reasonable time, and there's a little more flexibility there. And that makes logical sense if you think about it. Okay, now, focusing on the primary standards, let's go back and remember the Boomer cement case from the last chapter we looked at. Actually, it was Alfred Boomer versus the cement company. But if you remember that case, that was a case where the cement company is putting pollution out, it's landing on people's houses, and the judge had a very difficult decision. The decision was either to shut down the factory or to permit the factory to pay continuing damages to the people that the company is offending, the plaintiffs, in other words. And the judge held for the latter there. The judge said, we're not going to shut down the cement company. It's too important. This decision was actually central to the debates as the Clean Air Act was being developed. And Congress opted to go not the way Boomer went, but the way the dissent went, or the other way. The idea, for the primary standards, the idea is you will clean up, you will get the air as clean as it needs to be, or we'll shut down the factory. It's hard and fast. It's not based upon a reasonable time. It's based upon clean it up or shut it down. So it's the opposite of the Boomer cement case. This is going back to the Boomer cement case. I think it's Alfred Boomer versus the cement company. Okay, but the cement case. Remember we talked about last chapter a nuisance case where the plaintiff sues the cement company because the dust from the cement company is coming on his land, and the court was faced with an issue. Remember, the court was faced with the issue. Traditional nuisance says, stop the nuisance or we will shut you down. The alternative, which that court followed, the Boomer case, was the court said, we're going to let you pay permanent damages. We're going to let you pay your way out of this, in essence. As the Clean Air Act was being thought through and developed, Boomer had been decided, and it was sort of central to the debate. Are we going to follow Boomer as we outline the Clean Air Act, or are we going to do the traditional way of doing nuisance and say they have to clean it up? And the Clean Air Act went with the other way. They rejected Boomer and adopted a policy, an approach, so to speak, which we'll touch on later in this lecture and deal with more in next lecture, but that essentially said you have to clean up. You have to meet your air pollution rules. You have to eliminate the emissions and do the right thing, and if you don't, we will shut you down. It's not sort of a we're doing our best or it's a reasonable thing. It's the initial approach, the starting approach from the Clean Air Act, and I phrase it that way because the Clean Air Act has sort of moved a little bit. But the basic approach, the starting assumption with the Clean Air Act is you will clean up and meet your emission controls or you will be shut down. The part of the Clean Air Act you want to look at here, if you want to, probably after the lecture, pull it up from the PDF files we have, is Section 109, which sets the ambient air quality standards. The primary standards to protect human health with an adequate margin of safety to be established as soon as possible, in no event longer than 3 years. I guess it was originally 3 years. I think that may have been amended to 2 years. That's what's in my mind right now anyway. I probably should have looked that up before I started this lecture, but you please look it up, and somebody post that on the discussion board. Let me know if I'm wrong, if it's 3 years. But anyway, the point is it's a hard and fast time. It's not within a reasonable time. The secondary standards, however, are for a reasonable time. It's designed to protect, from known and unknown damages, but since it's not a human health matter, we're more willing to sort of work it in and tell people you got to pull it together. It doesn't have to be ready immediately. All right, let's take a look at a case working with Section 109. The Lead Industries Association versus EPA. As discussed earlier, lead, of course, is a significant pollutant, a lot of health effects. It's in the air, it's in from other sources as well. And so the EPA created regulations about how much lead could be permissible in ambient air. And we're talking about a primary standard here, the first standard, human health standard. So they set the standard. Then the lead industries, as you might deduce from that name, these are companies that work with lead, and they put lead in the air in their pollution. So it's they're a company that these are companies that are concerned that EPA is being too strict with them. So they challenged to have EPA explain how they came up with their numbers. So that's, I think, what's kind of interesting about this case, and it's sort of a slow work through, think through kind of thing to do. But what the EPA originally said was, we believe that the most susceptible to harm people are children ages 1 to 5. How do we test kids and know, or any people, but kids in this case? Well, there's a thing where you take some blood and you do what you call an EP elevation test. So you get a blood test and you look at their EP and determine whether it's elevated. They say, well, 15 micrograms of lead per deciliter of blood is the target, because that is the lowest level that is considered elevated. I guess if you're down to 14 micrograms, it would not be elevated. So 15 is elevated, but it's at the lowest level elevated. So that's where they want to aim for. But here's one of the things, though. They calculated that 12 micrograms of lead are going to come from non-air sources. Kids are going to pick up lead. Lead used to be used in plumbing, lead pipes, lead solder in pipes. It used to be used in paint, so kids would pick it up that way. I guess there are natural ways as well. But kids would get 12 of their permissible micrograms from non-air sources, meaning they could only get 3 micrograms from the air and still be at the target level. Moreover, here's the thing. 1 microgram of lead in a cubed meter of air leads to 2 micrograms in the blood. Therefore, and if you think this through, and if you need to stop and look at this, or pull up the case and look at it, please do so. But the thing is, the permissible level was therefore set at 1.5 micrograms per cube meter in the air on a 1-month average, because that would lead to 3 micrograms in the blood, and that would put kids at the target level. Now, kind of interesting point here, the same level was used for the primary standard and the secondary standard. Now, ask yourself, why in the world would that be? answer it on the next slide. Have you thought about why it would be that the same standard is used for the primary standard and the secondary standard, the same numbers? It is because the most susceptible thing on the face of the earth, the EPA concluded, to lead exposure are human children. So normally we think that we get a level that's safe for people, and then we may be more strict to protect the buildings, the plants, and the animals. But if children, or humans, are the most susceptible thing, then you don't need to be more strict to protect plants, buildings, and animals. You have already done that by just protecting people. So it's kind of an interesting point to keep in mind, but it all fits together. After the challenge to the lead industries, the challenge by the lead industries to the EPA standards, the case, you'll see the court walks through the final regulations. The EPA kind of did a different calculation, raising the permissible blood level from 15 to 30. So we're going to allow the EP level to go up to 30 instead of keeping it at 15. However, to make sure that 99.5% of the children will be kept below 30, we're going to bring it back to 15. So it's kind of funny. It's sort of like it's a give with one hand and take away with the other. We're not going to have the permissible level of 15 anymore. We're going to go to 30, but just to make sure everybody hits at 30, we're going to cut it down to 15. And so that means the whole analysis remains the same, and you stay at the same level in terms of ambient air quality. A couple other issues that were worth noting in here. There was a question about feasibility and cost. Lead industry says this is completely infeasible and it's going to be incredibly expensive. And the court says, looking at legislative history, we don't think that that stuff's supposed to even be considered. So, tough luck. Besides, the EPA is supposed to err on the side of caution. We're going to have some uncertainty. I mean, that's unavoidable. But if we wait until the EPA or the administrator can show harm, or we got to wait till kids start dying. How long do you wait? If you wait long enough, it may be too late. Once again, I close here with the question, why the same primary and secondary? But the answer is the same that I started out the slide with. All right, this brings us then to the Connecticut Copper Corporation case. A little alliteration there for you. Connecticut Copper versus EPA. Challenge is here to national secondary ambient air quality standards for sulfur oxides. Well, what happened here is the EPA concludes that there is harm at 85 micrograms per meter. There's harm to vegetation at that level. But they didn't set the level at 85, they set it at 60. Whether they were thinking about a margin of safety or whatever. Secondary standards don't have a margin of safety. Why not? Because they're supposed to be a margin of safety in and of themselves. The court here looks at what the EPA did and said, I can't really understand the agency's basis, and so remanded it for further explanation. When it got to remand, the EPA essentially capitulated, went along and raised it back up to 85. The EPA does have a duty in all of these cases to show why it is that they set their standards where they set them. And also, they have to be able to explain it in court. Now, that can be kind of difficult in situations where the science is unclear and the standard even is unclear. The standard with primary standards, there has to be an adequate margin of safety. Well, what does that mean? If you had evidence of harm at 85 and you set it at 60, maybe that would work for the primary standard. The secondary standard does not have a margin of safety, and that may be the difference. All right, and that brings us then to the Connecticut Copper Corporation case, Connecticut Copper Corporation versus the EPA. These are challenges this time to second. From the Connecticut case, there are a couple of points worth mentioning. The court here did not view this as traditional judicial review, but rather suggested that it was a partner with the EPA in setting these standards, which, I'm not sure where that comes from. It's not in the statute, but the court seemed to view that as a point. Here's a true story worth for our last slide for this lecture. California's Solar Shade Control Act protects solar panels from obstructions from sunlight, so you can't block the sunlight if someone has that up. In this case, the court ordered redwood trees to be cut down, which for the solar panels, which would not seem necessarily to be the best environmental thing, but I guess there are trade-offs that have to be made. See you in next lecture.